to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ms. Oplin, please, the TV coverage and roll call.
Thank you, Mr. Chair. Planning Commission hearings are televised live on Kenny Santa Barbara Television, CSB TV, Channel 20 at 9 a.m. in the South Coast, Lompoc, San Ynez Valley, Santa Maria, and Orca areas. Rebroadcasts of Planning Commission hearings are on Fridays at 5 p.m. on CSB TV, Channel 20. And for the roll call, Commissioner Brown.
Here.
Commissioner Jackson.
Here.
Commissioner Valencia.
Here.
Commissioner Cooney.
Here.
And for the record, Commissioner Blau is absent.
Thank you, Ms. Oplin. Good morning, Ms. Black.
Good morning, Mr. Chair, members of the commission. This morning we have 2 items on our regular agenda, and those are both ready for the commission to hear and take action on. We also have a uniform rules briefing by the long-range planning staff, which we'll take up under the divisional briefings.
Thank you. Any questions? Commissioner Jackson?
With a briefing, we're just being updated. This is not a vote issue or anything like that.
That's correct. In fact, Mr. Chair, some briefings, and you'll probably ask me why, and I'm not sure I have a great answer, but some briefings we actually put on the agenda, like the process improvement briefing that's on your agenda, and it's a matter that will be going to the board later on this month, and some we just do more casual briefings under the divisional briefings, like the uniform rules update that you'll hear this morning. So you'll see them in both flavors, and it's mostly related to the length of the briefing.
Good question, good answer. Thank you.
Like it when I ask my own questions.
The projection report, please.
Okay. Mr. Chair, next week we will be meeting in Santa Maria, and we have about 3.5 hours of work to do that day, so we're hopeful that we'll get most of the decisions made while Commissioner Blau is still present, because he will be only present until 2 o'clock. October 17th is a Montecito Planning Commission hearing. October 24th is a meeting back in Santa Barbara again, and Commissioner Jackson won't be present at that meeting. We have about 5 hours worth of work that day, and I believe that's the day we had scheduled the greenhouse gas briefing with both the Energy Division staff and APCD staff, as your commission had requested. And I'll have that put on the projection report once I confirm that that's the final date. November 7th, we'll come back with the Santa Barbara Ranch Transfer of Development Rights Project. It's the only item on that day so far. November 14th is in Santa Maria, and it's already a closed agenda. The 21st is the week of the Thanksgiving holiday, and none of the planning commissions will be meeting that week. November 28th, again, we're requesting that the commission move the hearing of that day to Santa Maria. We do have a number of projects that are ready for action, and that agenda is already full as well. Just so your commission knows, the Montecito Planning Commission will actually be meeting the following Thursday, the week after Thanksgiving, so November 29th. We have December 5th as, I believe, the last, well, we can talk about that, the last South County Planning Commission hearing of the year, unless your commission chooses to meet on December 19th. And I don't know if we've made that decision or not. We don't have anything scheduled on the projection report yet that day, but I believe it's the day we were proposing to come back with the housing workshop, the affordable housing workshop. And we'll confirm that as we get a little closer. December 12th, in Santa Maria, so far we have the Orchid Village Marketplace on the agenda, which is a pretty exciting project. And then again, as I said, I'm not sure if we'll have a planning commission hearing on December 19th, as it's getting pretty close to the holidays, but we can, I guess, decide as the year progresses and we see if we need it or not.
Commissioner Jackson.
Yes, correct me if this is the inappropriate time to ask this, but I could use a thumbnail of how a thing gets on our agenda, what the protocol and propriety is. It will have some bearing on some remarks later, so very brief.
Sure. Mr. Chair and Commissioner Jackson, we have the planners project for this blue projection report as soon as they feel confident about the date. So when they've released an environmental document or know a case is exempt and they feel like they can at least write the very first page of the staff report with some confidence, then they'll place it on this projection report. Occasionally things move around, but usually it's pretty clear that items are going to go forward if they're on this. I also do about a few times a year a little bit longer projection of larger projects, and those are usually targeting months. So that's
Maybe if I can drill down my question a little lower. I
Sure.
understand how it gets here.
right.
What is the protocol for agendizing? What does one need to keep in mind for proper noticing? That whole bailiwick is a little new to me.
Okay. Mr. Chair and Commissioner Jackson, we have to publicly notice items for consideration by your commission 10 days in advance of your hearing. So usually about 3 weeks out, we're pretty well certain about what's going to be on your agenda. 2 weeks out, we have to, about 2 weeks out, we have to notice in the newspaper of general circulation, whether that be Santa Maria Times or the News Press or what have you. So 2 weeks, it's absolutely certain. We can't put anything on the agenda after that point that requires that 10-day notice. Does that help?
That's specifically what I was looking for.
Good. Okay.
Ms. Black, two things. One, the obvious omission is Wednesday, the 31st of October, which would be a fifth Wednesday, and we're not planning a meeting on that date, correct?
Mr. Chair, that's correct.
And then, as far as the location of the meeting on November 24th,
28th.
28th, right. We discussed this briefly in our projection report last week, and I think it's the sense of the commission that we do want to hold that meeting in Santa Maria. Do we want a formal motion to that effect, or is it enough to just give instruction that?
I think it's enough just to give instruction, Mr. Chair.
Okay. That is the feeling of the commissioners, I take it. Okay.
Maybe, Mr. Chair, it might be appropriate just to find out if we did feel we needed to have a meeting on December 19th, if planning commissioners, actually, December 19th would be a regular Montecito Planning Commission date, wouldn't it? There's the possibility, depending on how these items go, that we may need to squeeze one more meeting in. So we'll talk about that as we get into the crazier season. But December 19th actually would be a Montecito Planning Commission date. So I do think December 12th is likely to be your last hearing.
We also have other dates during December, other than the Wednesdays, that we might look at for
Right.
a potential special meeting if
If
the
need
need
be.
arises.
Right. And then, Mr. Chair, I know Commissioner Brown asked about the Planning Commission luncheon. We have a holiday luncheon every year with the current and former planning commissioners and former directors and others. And we typically have that at your last meeting in December, and it tends to work out toward the beginning of December. So this year, it would make sense that it be on December 5th, if that's what the commission would like to do, and if you'd like to hold it in the South County. If it's something that you'd like to hold in the North County, then I'd suggest December 12th, but we typically do conduct that on a planning commission date. So you might want to give that some thought, and maybe we can talk about it next week.
Or we could vote today when Commissioner Blau's absent and just settle on the 5th. Let's keep that in mind, and
Okay.
we'll come back to it. Anything else on the projection report? All right, then we're ready to move to public comment, and I will remind the audience that this is the opportunity to comment on any matters that are not on today's agenda before the Planning Commission. We welcome input from the public at all times, but this is the time reserved in our meeting for that purpose. Are there any speaker slips for today's meeting? Commissioner Brown says no, and we don't have any as far as you know from the North County, Ms. Oplin? Okay. Then we'll move on to Planning Commissioner information reports. For the benefit of Commissioner Jackson, this is the opportunity we take to afford commissioners to address the commission on matters that they find of interest or of general interest to the commission. Commissioner Brown.
Thank you, Mr. Chair. Seeing the CEQA book that you have in front of you just has reminded me that I think with several new commissioners, and I'm a fairly new commissioner myself, that it might be helpful to us if we had a briefing on CEQA, not what it is, but how it applies to us and how we should be using it or considering it when we read documents, or what it means. And I'm not sure. It's a pretty big bear to get your arms around. So I'm thinking that if we have time in December, if that would be convenient for staff to provide that briefing, then as I look ahead to next year, when I see we've got some really big projects going to be before the commission, Lompoc Wind Energy, Tranqueon Ridge, I'm sure there's some others, that it might be very helpful to have, particularly for the new commissioners, this background, so as they start reading these EIRs, the EIRs sort of light up and provide more information and are more meaningful in terms of CEQA.
Ms. Black.
Mr. Chair and Commissioner Brown, I think that's an excellent idea. Actually, County Council is preparing to give my staff training, and so it'll fit nicely. I don't think it would necessarily make sense to have exactly the same training for the Planning Commission as the staff, but I think we can use elements of that training to provide information to the Planning Commission and have a discussion about CEQA review.
Is that December 5th date too early?
I think that would work.
Okay,
I'm
great.
looking at Marianne because I know she's one of the presenters.
Okay, great.
Ed
Thank you.
Yates and Marianne Slutsky, so we'll coordinate with them
Good.
and
Thank
see if we
you.
can find a date.
Commissioner Valencia.
Thank you, Mr. Chair. And along with that, could we get some new CEQA documents? All right, thank you very much.
Commissioner Jackson.
I don't know if I'm cutting somebody off or but I'm
It's your
signaling.
turn.
Okay,
You're
all
up.
right. I don't know where this is appropriate, but as I've been digesting over the last week since my leap into the pool last week, I've come across an observation, and as I look forward to meatier projects, as we evaluate them, one of them, we've already had an introduction to what I would call a meaty one. And without going into specific in that one, I saw fairly obvious ways to component break down the volume of those decisions. But I don't know the process by where that could take place. And one of the reasons I say that is I envision somewhat a little bit of a train wreck is we will be inviting the public to participate, and it's an important component that their participation on the 7th of November, and they will be speaking to it in its entirety, as opposed to looking at what I saw just in my, and I'm not finished yet, analysis, rather core compartments of concepts that are germane to the decision that we'll be looking at. And I recognize, in part of my question earlier on how things are agendized, is it doesn't look like we have a very good method for safety valve dice up these projects to focus on core issues. And I think at this juncture, over the course of the coming weeks, to advise me as to how from my perspective of wanting to make the information manageable, how we might go forward looking at these larger ones in a fashion where we can take the core issues, give them the time, invite perhaps the public response to the core portion as opposed to it in some, and it might be more beneficial. And I'm wrestling with this, and perhaps there's experience and perhaps this is not new, but this is where I'm wrestling. And part of this comes down to I feel that it will be my duty to, over the course of the coming weeks with the complex ones, meet with the planner and do my homework. But the invitation to the public seems rather critical to moving these things along, and I guess I would just like some insight into that, to where I'm going.
Do you want to start, Ms. Black?
I'll start, and perhaps Commissioner Cooney will want to add something to this, because the chair serves a role as well. But my staff is happy to meet with any planning commissioner who has ideas about the best way to present information to the commission and to the public, and to parse out a decision so it makes sense both to you and to the public. So I'd welcome that, meeting with Mr. Fagan and myself on that particular project. We often also work with the chair on these larger projects to figure out how we might best get through the information and present it to both your commission and the public, and maybe you want to add something to that.
What I would say, in general, Commissioner Jackson, is that there's no perfect template for the larger projects. What starts out to be very general often becomes more specific as the issues are presented, not only by staff to the commission, but through the initial public hearings. And at the end of one or more hearings, we often have a better idea of what issues we really need to focus on. But I think our tendency, and it's appropriate, is not to exclude discussion of any aspect of a hearing that might be relevant to members of the public. In fact, we can't presume that what we receive from our staff, despite their close acquaintance with projects, covers all the issues. And we often add to the list of important issues to discuss at the end of one or more public hearings. So I do think it's constantly a work in progress to see how to manage these larger projects. And something like Santa Barbara Ranch is, we initially had our first hearing and our site visit, I think, over a year ago, and we're just coming back now with this one aspect of it, this transfer of development rights, but we haven't even approached the substance of the project itself and what other possibilities might be there. So that definitely is evolving. I understand the need to focus the public and the discussion at times on particular areas, and that tends to be done at the time of the hearing. The chair sets the stage for the hearing, and the public generally responds very well to that. And we have, in other cases, for example, the San Marcos Foothills project, we've specifically divided it up and said, today we're going to talk about the public access to the property, for example, and a whole hearing would just be on that issue. And then the next time we'll cover something else. So while I would suggest that your concern is certainly well-based, you will see these unfold in the context of specific hearings, and we'd welcome your input as to how it should be done more efficiently. Anything else, Commissioner Jackson?
No, I think that sum is, I'm just going to seek you out, and I'll seek everybody out to race to catch up. But I appreciate that structure, and I will learn to swim accordingly.
Well, I think you're already well learning. It's sink or swim up here. I would like to take a few minutes of the commission and staff's time to address one of the cases that has been swirling around, and it coincidentally addresses the point raised by Commissioner Brown, that is background on the California Environmental Quality Act, which is a part of many of our projects, but where we typically read the reports, we're not sure why all the things that are discussed in the CEQA documents are there and why other things aren't. The California Supreme Court earlier this year decided a CEQA case that I think is important for the commissioners, as we are on the front battle lines of these projects, and we need to understand the guidelines better. And I look forward to an opportunity to have both legal and non-legal staff address us generally on the CEQA provisions. But just to dive a little bit deeper into this one case, I have passed out copies to the commissioners, and I'd welcome a further discussion after you have a chance to read through it. But suffice to say, this case has been recognized by land use attorneys throughout the state as significant in that it is addressing in particular the element of water supplies to large projects. And with the projections of increasing population in California and throughout Southern California in particular, how governmental agencies analyze the water supply to future projects is very important. And the court attempts in this lengthy decision to give guidance to local governments. And I think even though our growth issues tend to be more narrowly focused, we can learn from this decision and from the decisions that are certain to follow in the way of guidelines. Just a bit about the facts. This was a huge development by any standard. It was a decision by originally the County of Sacramento to adopt a whole community plan, and the close example I can think of in our recent history is the North Hills project near Orchid, where an entire community was being planned and presented initially to the Planning Commission and then the Board of Supervisors. It was a plan that encompassed some 6,000 acres and 22,000 residential units to be phased over time, but it included schools and shopping centers and all the other things that were included with the North Hills project as well. And the question was water supply to this project. And the environmental document prepared by staff and its consultants addressed water in many ways. As I recall, the main supply was a new field of wells, some 16 new wells that were to be drilled. But this was challenged by a citizen group, and initially it went to the Superior Court in Sacramento County, and the court upheld the county's approval of the project. And then it went to the Court of Appeal, and the Court of Appeal did the same thing. It upheld the CEQA review, and then the Supreme Court took the issue up. After the Supreme Court decided that more CEQA analysis was needed, it went back to the Court of Appeal, which issued a spirited opinion expressing some concern about the project and maybe even implying that the Supreme Court missed certain points, but nonetheless passed the matter back to the Superior Court for direction to redo the CEQA analysis as to water. We in our county, in my brief experience, have only had projects which have gone through the initial stages of the Planning Commission and the Board of Supervisors. A CEQA challenge to the Montecito Commission's action and then the board's adoption of the Westmont project last year is in Superior Court at this time. So there's a real life example of a case that is going forward just on the question of whether the CEQA analysis was sufficient. Often this is done by a project opponent because the CEQA analysis is by statute to be addressed with priority by the Superior Court. So it's the first stage, if you will, of the review of a project. And this particular decision that we're looking at today, the Vineyard Area Citizens for Responsible Growth, is an example of the litigation process overtaking a project. The Board of Supervisors approved it in 2002. This decision was handed down early in 2007, and it's probably only in the Sacramento Superior Court now. So soon it will be back to the county of Sacramento, now actually the city of Rancho Cordova, which has been incorporated since. And there'll be a new CEQA analysis. And then just to take one more minute as to the issues, the court was concerned about the analysis of the water supply issue, not the short-term water supply, which was identified, but since this project was being phased, in the final phases, statements were made in the environmental impact report and then adopted by the Board of Supervisors that if these water supplies don't materialize or something happens that they're not available, we'll just curtail those final stages of the project. And the court said that is not a sufficient CEQA analysis in the first place. You need to identify the long-range water supplies. You need to take into account the competing interests for those water supplies. And furthermore, you need to take into account alternatives if those particular supplies you're predicting will be available turn out not to be. And that's a tough nut to crack. I think that really raises the bar for CEQA analysis, and we'll be looking for that in our reports. That is not just the current supply, for example, the Santa Maria water basin as the ultimate water source for projects in the North County, but what competing interests might there be for that water supply in the future, and has that been adequately analyzed? We do, I think, have a chance of feeling fairly soon the effects of this decision. And I mentioned to council earlier the Court of Appeal in our area, the 6th Division of the 2nd District Court of Appeal handed down a decision just last week, and I'll give it to council to look at. But it not only cited, but closely followed the instructions of the California Supreme Court in connection with the Newhall Land and Cattle Company application for significant residential project in our area. So it's getting close to us here, and I think it's beneficial for us to look not just at this case, but in general how CEQA analysis should be done and how we can do a better job of it here. Commissioner Valencia.
Thank you, Mr. Chair. That is very interesting, and it just dovetails into what's happening in the 4th District. As you're familiar with the PXP project up there, it's a project that probably is in the county and should come to the county, but they've proposed to annex to the city of Lompoc. In its proposal to annex, and I'm not giving a position pro or con, they're asking annexation to the city. They'll be going before LAFCO. And very concerned about the CEQA analysis in that there isn't any water for that project. They have to buy water from the city of Carpinteria. That is state water. The voters in the city of Lompoc voted overwhelmingly not to take state water. And now here's a project that's trying to impose itself on the city. The city is a full general service city, provides all the services, and now there would be an island in the city with a separate water need. The state water is only, 75% reliable. If they had a problem, where would the responsibility lie? And so the CEQA analysis would be extremely valuable in this particular case. At a briefing to the general public initially by the PXP personnel, they indicated that they had been to CEQA, and I challenged them at the meeting. I said, you have not been to CEQA. What they had done is they'd made a phone call, and they...
You mean LAFCO?
To LAFCO, yes.
LAFCO, right.
And they misled the people. And so we have to be very careful, again, in understanding CEQA. That's why the CEQA presentation requested by Commissioner Brown would be so valuable to us, of knowing how to protect not only the county and the districts, but our own communities. So I appreciate that, and I appreciate you bringing in this opinion. Thank you, Mr. Chair.
Commissioner Valencia, you'll be interested in reading this opinion later in your leisure time, to note that the Supreme Court terms state water rights transferred from one jurisdiction to another as paper water. And they draw a distinction between the reliability of paper water to actual water supplies. So it certainly sounds like it's pertinent to that question. Thanks for you can understand why I've put off addressing this case. It does take a few minutes even to introduce it, and we haven't had much time on our agendas, but I thought I'd take advantage of a light agenda today to do that. We next have the opportunity to hear from staff with regard to some of the other issues that provide background for our specific project considerations. And Ms. Black, perhaps you could introduce the divisional briefings.
Yes, Mr. Chair, we do have one divisional briefing this morning at the request of your commission, and that is from long-range planning staff, David Mattson and John McGinnis, on the Uniform Rules project that was recently adopted by the board.
Good morning, Mr. McGinnis, Mr. Mattson.
Good morning, Mr. Chair, Commissioners. As Diane mentioned, you had asked that we come back after the board hearing and let you know what happened and what was discussed. As Diane did state, last Tuesday, September 25th, the board adopted the uniform rules. The decision marked the end of a 4-year effort to bring the rules into compliance with state law and also to provide some additional flexibility to those enrolled in this voluntary program. As you may recall, we were before your commission at the end of last year, 2006, with proposed rules and corresponding environmental documentation. We then took those to the board for consideration, and on February 13th, the board directed that, in fact, the CEQA document should require some additional revisions, specifically the cumulative impact section. So on that date, the board directed us to revise the cumulative impact section of the proposed final draft EIR to the uniform rules and bring it back to the board for further consideration. Between February and last week, we worked diligently to address the concerns that we heard both from the public as well as the board in the cumulative section. We had, in fact, a Saturday workshop on the matter as far as what types of projects and issues might be addressed and included in that section analysis. And just to sum up what we ended up with in that revised document, there were no additional Class 1 impacts identified in the expanded analysis. In fact, I think the document highlighted that a majority of the cumulative projects considered in the revision were unrelated to the uniform rules, and that the uniform rules contribution to the overall pool was not cumulatively considerable. Nevertheless, the document, as it stood, did contain or confirm findings of the original EIR, noting 10 Class 1 impacts spread over 5 specific CEQA-defined resource areas. So there were already all of these Class 1 impacts that were identified in the original document. I think the cumulative impacts section probably was one of the more extensive cumulative impact sections that I've seen in 25 years of looking at CEQA documents. I think it was a very good summary of all that's going on in the county from all the different projects that are either occurring or have been proposed. And so I would encourage you, if you haven't had an opportunity to look at that document, to take a look at it, because I think it does a good job of explaining all the different projects that are out there on the ground today.
I think inadvertently that document wasn't provided to the commissioners, so we'd ask maybe that we could get copies of that.
Absolutely.
I think in particular the cumulative impacts discussion may be relevant to other projects that come before the commission in the future.
Absolutely. And just one other kind of side note I will mention, we're really looking at this document or this cumulative impact section as kind of a blueprint for future EIRs that will be developed. So it's very thorough. It's probably more thorough, as I said, than any other cumulative section I've seen in any EIR around the state, but also in Santa Barbara County, and I think it'll be instructional and helpful and ensure that, in fact, we have adequate EIRs moving forward. We went through the whole required public information process in the review of the draft cumulative impact section. In July, we recirculated the EIR and the revised cumulative impacts discussion. There was a public review period. We held a public hearing in Solvang. Got a great turnout for that. I believe Commissioner Jackson attended that hearing and received a good deal of public input on the document. And then taking all that information, we incorporated it, addressed comments, both written and what we received at the public comment, into the document, and brought forward the final EIR last week for the Board of Supervisors' consideration. The hearing was extensive. If you didn't have the pleasure of watching the hearing, it was about a 4-hour hearing, and we had a significant amount of testimony at the hearing. Various different perspectives and opinions were provided to the board in their consideration. I think we had 29 speakers, and there was a significant amount of discussion and questions on behalf of the board of many of those speakers, and after careful deliberation, the board voted 4-0 to certify the final EIR, adopt the findings and statements of overriding consideration, and approve the amended uniform rules. They did make several changes, the board did, in their action, and I would just point them out to you. The first, they decided to reduce the development envelope for commercial composting from 35 to 20 acres. That would be the maximum envelope for a composting facility. Second, they eliminated the rule allowing guest ranches on contracted lands. And third, they eliminated the extension of the agricultural industrial overlay, which is codified, as you probably know, in the ag element. They eliminated the application of that to lands under contract. So those were the three things, the three major modifications that were made to the proposed rules. We also made some specific recommendations in response to some of the testimony that we received over several months, both in previous board hearings and through community workshops. The first, and the board did include in their motion to adopt our recommendations on the 4 items. The first had to do with striking the term sports fields from the list of incompatible uses. Second was to include a provision to allow for non-continuous winery envelope development. It wouldn't change the maximum envelope of a winery, but it wouldn't require that all of the activities in that envelope be contiguous on that single parcel. Third, we proposed, and they confirmed, to eliminate the rule proposing to allow for small-scale agricultural processing facilities. That is not an allowed use in the underlying zoning as it was today, and that was kind of a principle in moving forward with these rules, as we didn't want to create new uses that didn't already exist in the underlying zoning. And then similarly, a member of the public had requested that storage of well drilling equipment be considered a compatible use on contracted lands. The issue there was that it's not an allowed use in the underlying zoning, and so that request was not included into the rules modification. So all in all, I think that we ended up at the end of the day with a set of rules that all of the parties, clearly by the action and the unanimous vote by the sitting board members that day, achieved the objectives and addressed most of the concerns of the people who testified at the hearing. And I guess I would like to thank your commission for all the deliberation we went through in the previous year to get to that, to get to the point we got to last week. I think it was a successful process. In the end, it was not necessarily the most enjoyable process at times, but I think that it's a very important project that ultimately the intent of the project, I believe, will be achieved, which is to preserve agriculture long into the future and recognize it as a key component of land use in Santa Barbara County. So that's a summary of where we've been and the action that the board took last week. Be happy to answer questions. David Mattson is really an expert on uniform rules now, certainly, and CEQA application, but just wanted to come back both at your request, and I appreciate the opportunity to let you know what happened and the dialogue that occurred.
We do have some questions. Commissioner Valencia.
Thank you, Mr. Chair. Mr. McInnes, on the soccer, the sports fields, they took that out, but if there isn't any grading, don't they allow soccer to still be played on some of those lands, such as in Carpinteria?
Mr. Chair, Commissioner Valencia, the specific action that they did was to delete the reference of sports fields in the rules as a non-compatible use. It doesn't infer that sports fields is a compatible use. In fact, we've received written communication from the State Department of Conservation that, in fact, it's not necessarily a use if that's the primary use. So what would happen is that if people come forward with proposals, the Agricultural Preserve Advisory Committee, which rules and determines appropriate uses on contract lands for the County of Santa Barbara, would consider each case on its own basis. And it is a bit of a sticky wicket. What has happened is that someone will come in and say they have a sod farm, for instance, when really the primary use is intended to be a sports field. And so clearly that would not be acceptable in the eyes of the state. If it clearly is a sod farm, for instance, using this example, and there's one event a year or something that happens to occur out there, it could be that, or more than one event, but the primary use is clearly a sod farm or something that's related to, and primary use is defined as agriculture.
Well,
then
if
that
you
would be
have
a
one
discussion.
crop, if you do one crop, and then after the one crop, it's a one crop, could you, if you didn't do any tilling or anything, could they use the field? I thought I read something to that effect, and it wasn't very clear. That
Well, it's not clear, and it will be dealt with on a case-by-case
Okay.
basis by the Ag Preserve Advisory Committee.
All
And
right,
I think that was the wish of the board.
All right.
Yeah.
And then the second question was with respect to RAUs. You had a matrix in your presentation that showed the parcels from Ag 1s and Ag 2s, and then a breakdown of 5, 10, 20, 40, 100, 320, and so on. And then you had a listing of where you had original house, guest house, ranch house, RAU, what was permitted. And on one of those breakdowns, I think you eliminated an RAU, didn't you?
Chairman Cooney and Commissioner Valencia. RAUs, I think it's important to understand that it is a pilot program. It was started in 1999. It sunsets next summer in July. And your commission and
RAU being,
residential agricultural unit.
thank you.
Simply
Rental.
put, it's much like a residential second unit. It has specific development standard requirements for it under the pilot program. This pilot program provides this opportunity for RAUs, residential agricultural units, on contracted land only. So it's already a use that isn't provided for in the underlying agricultural zone district. So that's one issue for discussion when you consider this program. And whether or not to allow it to sunset, to make modifications to the current ordinance, or to have the program continue as is, but some action will be needed. RAUs, since the program's inception, there's been 15 built in the county. There hasn't been a lot of them. And it is distinctively different. The rules are different from, as you mentioned, the principal dwellings, the second and third principal dwellings that are now allowed under the rules based on certain development standards as well. So we didn't eliminate residential agricultural units. There was no additional provisions for farm worker units or agricultural type units within the rules themselves, and this really, the RAU ordinance is a standalone ordinance that happens to apply only to contracted land.
Thank you, Mr. Chair. Thank you.
Thanks, Mr. Mattson. Commissioner Jackson.
Just two quick items. I presume our collective understanding and our collective knowledge may have moved forward with regard to the fact that when like-minded projects are on track to be part of the docket at the same time with what may appear or may actually be overlapping similarities, that will keep in the forefront of our minds how that is perceived by the public, because I do know that that was a significant issue of seeing the interrelationship amongst multiple projects arriving on the public agenda at the same time, seemingly overlapping or contradicting. And I'm presuming our collective understanding will keep that sensitivity in mind as we go forward, and I congratulate you on the study of the cumulative impacts, which became quite a concept for the community in which I live, as well as my district. Number two, can you tell me, looking ahead, and for me personally, is there going to be a role for this commission in involvement in the uniform rules going forward in the short run, or is this essentially a concluded item?
Mr. Chair, Commissioner Jackson, the uniform rules are actually enforced and overseen by a sister committee, which is appointed by the board, and that is the Agricultural Preserve Advisory Committee. There will be pieces that your commission will see, such as the residential agricultural unit ordinance, other potential, you'll touch on the agricultural lands through various briefings and initiatives that will be brought forward through our work program, whether it's housing element issues, whether it's 661 issues, et cetera. But it really is the APAC that oversees the rules and implementation of the rules themselves. And as you know, but for the viewing audience, the rules are simply the rules that govern the contractual relationship between the county and a landowner for the purpose of a tax break. So this is making sure that the contractual arrangements between the county and the property owners it's what governs and allowed uses incorporated within those contracts. And so really that's the role of the APAC, is to ensure that the rules are reflected in the contractual arrangements. One thing I would mention, and that is one of the issues that the Board of Supervisors did bring up in the deliberations was the monitoring and enforcement of what happens out in the lands. And as we all know, that's not distinct to lands that are under contract, but also relate to all of the lands that are within the county's jurisdiction, and our people conforming to the zoning and the uses that are allowed, and do people have permits, et cetera. And that has and will continue to be an important issue. for us to address. And one of the things that we're in the process of doing specific to our affordable housing stock that the County Housing and Community Development Department oversees is developing a more advanced monitoring and enforcement program where, in fact, the Housing and Community Development Department is looking to have a full-time enforcement officer. And the intent there was to address the affordable units that that department oversees. We are discussing with both that department and Mr. Gillette, the Ag Commissioner, who runs the Ag Preserve Advisory Committee and oversees the uniform rules. The three of us are coming together to see where we can utilize this new monitoring enforcement protocol and resource and how it can apply to the lands under contract in the pertaining to the uniform rules. So that's something that we're taking a closer look at. But long answer to your question, the APAC is really the sister commission that oversees the uniform rules. You will get reports from us on what's going on and tangentially as it relates to housing or other activities that take place out there. So.
Yes, in addition, Mr. McGinnis, I'm sure you recognize that certain projects that are presented to the commission for lands under contract have issues that overlap with regard to the degree of development on the property, and often we look for action having been taken by the Ag Preserve Advisory Committee with regard to existing uses and whether additional uses are compatible and so forth. And so to that extent, I know we're constantly in touch with the uniform rules, even if we're one step removed from the actual interpretation of those rules. So I expect that we'll have direct involvement in that sense, indirect in the sense that we deal with all cumulative development in a particular community. And in that regard, I had a question. I know you've stated it numerous times, but I'm always impressed what percentage of Santa Barbara County's ag lands and lands in general currently are under contract?
Currently, there's approximately 550,000 acres that are under contract, and that represents 73% of all the lands. So it's significant of the ag lands.
Privately held agricultural.
Privately held agricultural lands. So it's a significant amount of land. And in fact, we are probably one of the more successful counties in California with respect to the Williamson Act and Ag Preserve contracts. And I think that reflects our value of agriculture in the community in Santa Barbara County. So we've been very successful, and I think that was one of the certainly the goals of modifying these rules was to ensure for that success into the future. So large block of land in Santa Barbara County under contract.
Thanks. I think it doesn't hurt to emphasize that point, and it makes more obvious the fact that the Planning Commission will constantly be involved in at least awareness of the impact of the uniform rules on development on ag lands generally. The second question I had is with respect to these revised rules. What is the role of the Department of Conservation? Does it have an approval role? Is it something that they can comment on, or when adopted by the board in final form, is that the end of the story?
Chairman Cooney, the Department of Conservation certainly reviews the rules for consistency with the intent of the Land Conservation Act, the Williamson Act. They also have the ability to exercise judgments as to the compatibility of land uses that occur on contracted lands. They can file, for example, material breach proceedings against the contract holder They can also act as a review body or an arbiter with respect to third-party complaints that have been brought forward. Have an active dialogue, certainly, with all of the local jurisdictions that participate in the Williamson Act program. They ultimately do determine whether or not a set of uniform rules by a participating jurisdiction is compliant with, and they advise those jurisdictions when changes are made, legislative changes, or changes in interpretation based upon case law or rulings related to contracted land.
So in this case, they would look closely at the changes that were made by the board and let you know formally or informally whether they have determined an inconsistency or not.
That is correct. We will certainly submit a copy of the final rules to the Department of Conservation and work with them to answer any questions that they may have.
Great.
I might just briefly add to that. We have, obviously, this has been an iterative process with the Department of Conservation, and as part of what was presented to the Board of Supervisors, we didn't want for the county to adopt a set of rules that we didn't have a high level of confidence were acceptable to the State Department of Conservation, and in fact, they indicated to us formally that the proposed rules were consistent. So I believe that there shouldn't be any problems. We have no concerns that any of those rules are inconsistent or incompatible with the State Williamson Act. And then finally, this is not similar to the housing element in that they do not play a certification role in certifying these rules. They simply provide guidance and counsel, which we have taken very close to heart, so that we are consistent into the future. So,
Interesting. Well, we very much appreciate the briefing and the update, recognizing I think that the role of our commission with that of the Ag Preserve Advisory Commission is close, and we do need to stay in touch, and we'll be interested in the development of projects related to the changes in the rules as well as to the rules that stood before they were modified. So maybe 6 months or longer out, you can come back with some kind of report as to what exactly has been done in the way of development on ag lands, which you can relate in some way to these rule changes. Anything else from the commission? Again, thank you, Mr. McGinnis, Mr. Mattson. And if you probably made a note, but we would appreciate getting a copy of the cumulative impacts EIR supplement. Great. All right, the next matter on our agenda is the director's report. Back to you, Ms. Black, for that.
Mr. Chair and members of the commission, Mr. Baker is out of town, and so I just wanted, and there was no board hearing yesterday, so I just had one announcement to make, actually two announcements to make to the commission. The first is we have filled the position that was vacated by Ms. Mendoza, and I'm happy to announce that we've promoted David Villalobos to that position. So David's in the audience, and I just wanted to let the commission know. So on an upcoming agenda, you will see our request, and it's a strong request, that you appoint him as the recording secretary. Because if you don't, I don't know what we would do, because we've never confronted that situation. But congratulations to David. We're very pleased. And then the second is another person sitting in the audience. Sharon Foster has been hired by the department as well to help out in hearing support. And so you'll be seeing Ms. Foster, and as will other boards and commissions. So we have David's vacated position to fill, and then I think we're full. So I think the commission will be in very good hands.
Thank you, Ms. Black. Congratulations. Mr. Villalobos. We welcome your increased role, and certainly appreciate the work you've done up to this point during this difficult transition, and Ms. Oplin as well. Speaking as one commissioner, I just haven't seen a beat missed, and a tremendous amount of effort must be behind the scenes. And Ms. Foster, welcome.
Okay.
Nothing else on the director's report, Ms. Black?
Well, Mr. Chair, I did attend the California chapter of the APA's conference up in San Jose. I actually had to leave a bit early to get back to the commission, American Planning Association. And I'm not, my thoughts aren't quite all together, but I can tell you I went to some very good sessions on global warming. I went to 2, and I had received quite a bit of written information, so we'll incorporate that into the briefing to the commission that we hold later on in the month. I also went to a session on tribal consultation, the tribal consultation process, and I've not forgotten that Commissioner Jackson's requested a briefing on that either, but it's going to require a bit more coordination, and we'll certainly incorporate that. It made it clearer in my mind as to what the requirements are. And it made it clear that everybody in the state's struggling a bit to meld the consultation process with the CEQA process, or maybe unmeld it, because I think it tends to meld together. I also went to a session on the care and feeding of commissions, which is quite interesting. The best quote from that one was, there was a woman that sat on the design review board for some local government, and she said the hardest concept that she had to deal with was what the design review board did and what the planning commission did. And she said somebody explained it to her really well, and that was the design review board looks at the tuxedo on the monkey, not the monkey. The planning commission gets to look at the monkey, meaning the design review board looks at design elements of the project and site planning, but not the use per se. So I thought that was a good explanation, because I've struggled particularly with the BAR, who does review and implement some of our comprehensive plan policies and zoning ordinance requirements. They do help us implement those, but their role is really different than the Planning Commission. So I thought that was quite a clever way to describe it. And those were the 3 that sort of struck me the most, but I did attend some other sessions as well, takings and exactions session, and unfortunately missed the CEQA update because it was being conducted today. So I'll provide you more information as we go through these briefings, and hopefully dispense some of the information I learned. And other than that, I don't think I have anything else to add this morning.
Well, thank you. That sounds like a very worthwhile conference, and thanks for taking the time to go up there and also to race back so you could be here for us. Obviously, we're going to need more background on the study and care of monkeys.
No, you aren't the monkeys. You review the monkeys.
Okay. That brings us to our standard agenda. The first matter will be the Lookout Park weed removal, and are we ready to go on that? Okay. Item number 1, if Ms. Oplin will read it into the record, we'll go right to it.
Thank you, Mr. Chair. The following is the hearing on the request of David Chang of the County Agricultural Commissioner's Office to consider case number 07-DVP-25, application filed on September 5th, 2007, for approval of a development plan and to accept the exemption pursuant to sections 15304, 15307, and 15333 of the state guidelines for implementation of CEQA.
Members of the commission, any site visits or ex parte communications? I did drive by the site last night to identify the species about which we're concerned. And I would just share with the commission, my impression is that however it's dealt with, there's a very significant invasion by this species at Lookout Park. So I'll look forward to the report of staff.
Thank you, Mr. Chair and Commissioners.
Before you start, Commissioner Valencia, did you?
Well, no, it
Okay, fine, excuse me.
The proposed project is at Lookout Park in Summerlin at the end of Evans Avenue. The project is solely within the county parks jurisdiction. This is a project being conducted by the county's Agricultural Commissioner's Office and also supported by the Parks Department. And I'll show you a close-up, a better picture of where the Arundel Donax is. Shoot, that didn't come out as well as I thought it would. The project is to remove Arundel Donax, which is highly invasive. It's primarily located in the county's creeks, but if you can see the beaches at off La Conchita, you can see the debris on the beach is primarily Arundel Donax. I'll show you the locations of the Arundel at the park here. This is the biggest location right here. This is the access, public access down to the beach. There's also a big clump here and several clumps along here. This is further west down the beach. There are little patches of it along the bluff toe as well. Okay. The Arundel will be, in the first year, will be removed by the cut stump method, which involves taking a chainsaw to the Arundel first and then applying glyphosate, an herbicide, to the stump. The glyphosate has a dye in it and is applied directly to the stump in very localized areas, and then it infiltrates down to the roots and kills it that way. There may also be some foliar treatment if it resprouts during the first year. And then they anticipate having to go back with it every year, possibly up to 5 years, to hit localized sprouts of the foliage as well. The primary issues that we looked at were herbicide use and beach access. Agricultural Commissioner's Office is responsible for permitting the use of pesticides throughout the county, so they're very familiar with the use of pesticides and have best management practices that they utilize. One of which is they're going to be having a licensed, someone who's licensed to use the glyphosate out there applying it. They'll have someone standing there watching it being applied and ensure that the public does not come in contact with it while it's drying. It takes about 15 minutes to dry. So it will not preclude beach access at all. It's anticipated to take about 3 weeks during the fall, and let's see, they're going to be doing it only on weekdays as well. So our recommendation is to adopt the required findings, accept the CEQA exemption, and approve the project subject to the conditions of approval. I thought I might add that we're here before you because it does require a development plan, because it's in the Recreation Zone District. That's why we're here today. That concludes my presentation.
Thank you, Ms. Gibbs. Questions from commissioners? Commissioner Brown?
Thank you. Is there an optimal time of the year to do this? And is this the optimal time of the year? I see Mr. Chang is sitting here, so.
Mr. Chair, Commissioner Brown, yes, the fall is,
the
late
optimal
summer,
time.
fall is the optimal time.
I would just be interested to know the country of origin of this invasive exotic, and how is it, or maybe it's not even maintained or curtailed in its country of origin?
Mr. Chair, Commissioners, my name is David Chang. I'm with the County Agricultural Commissioner's Office in the County of Santa Barbara. Arundel Donax originates from the Asia Minor, India, the continent, and it's basically worldwide in distribution now. It is an invasive exotic noxious weed, considered invasive and exotic in Santa Barbara County, and as such, it is usually a weed that is of limited distribution, which is one of the reasons why we go after it, because there is opportunity to get rid of it where it occurs.
But I see it, I live near San Jose Creek, and there are clumps along the creek, even though the creek was maybe 10 years ago completely cleared and revegetated. So just interesting how it got there. I mean, it was just a piece that was cut off and established itself, and that's how it got in this area?
I would say it's a bit of a mystery how it does get around. It is pieces. It is a vegetative reproduction on it. It's mostly the rhizomes that would cause establishment when they get in the area. Another process is layering, but that's usually localized spread. It doesn't produce seed, which is really unusual. It does flower, but the seeds are blank.
Any way we can use this material, this cellulosic material, for ethanol?
That's a controversy in the issue, and the hard part is getting it to the companies that would use it.
Commissioner Valencia.
Thank you, Mr. Chair. How does this differ from just, mowing the lawn or doing maintenance or cutting weeds? Why does this require a commission approval?
Well, it's an invasive weed, which means that it can displace other desirable plants and wildlife. It's not very good wildlife habitat, and so this is the reason why we're removing it. It's particularly detrimental for wildlife.
I understand that, but normally, like when you do normal maintenance, why wouldn't you just cut it then? Why does it require council action for us to approve that? That's what I'm wondering.
Commissioner Valencia's question is jurisdictional. This is unusual. I think Ms. Gibbs touched on it, and maybe you want to elaborate so we understand. My questions also run to that. That is, we have a County Parks Commission. Has that commission reviewed this application? And secondly, if it applies in Lookout Park, would it not apply to other coastal parks up and down the county? And so might we expect more applications like this in the future?
Mr. Chair, Commissioner Valencia, I'll answer the first question in that we looked to see whether this project was exempt from permits altogether, and unfortunately it's not, because it is removal of vegetation greater than half an acre, which is the guideline by the Coastal Commission. Yeah, so it does require a permit. We are expecting to see more of these projects in the future. This is part of a county-wide effort by the Agricultural Commissioner's Office where they're planning to do arunda removal in several county parks. And we are interested in working with David to try to streamline this effort. I'm thinking possibly rolling all of the projects into another development plan would be wise. There's an overall effort of the county to look at streamlining for beneficial projects, and a couple other efforts going on with the Land Trust and Community Environmental Council and such, but we are expecting to see more of this in the future, and we're working on trying to see how we can streamline these things.
And in terms of the project itself and anticipating that this may come up again, whether you are able to put together several applications and put it into one review, I think the biggest concern for me, this particular park being in the first district, is whether we've done an adequate job of environmental review. There is a tremendous amount of literature out there now that's current about the use of pesticides and far-ranging effects of those pesticides. I'm not at all familiar with this particular use and application. The report does say that measures are being taken for safety purposes, but I guess the threshold question I have, perhaps Mr. Chang is the one to answer it, is whether this particular application of pesticide is necessary, or whether simply removing the species from its current location would buy enough time so that we could deal with it as we do weeds and grass in other areas of our county parks.
Well, this is a particularly vigorous plant, and as it is a grass, and like you mow your own grass. If you were just to cut this particular grass, arundo, it would re-sprout from the rhizomes or from the roots. So digging it out is another method, but digging out in this particular area would be hazardous, basically to the cliff and to the park. It's not a good method of trying to remove arundo. Herbicides basically are the way to get rid of this particular weed. There would be there is an alternative method of tarping, but it has yet to prove itself amongst practitioners of this type of weed control.
You have
Mr.
something to add, Ms. Gibbs?
Yes, Mr. Chair, actually, and it does qualify for the exemption, a recent exemption that was added that exempts small restoration projects that do not involve heavy equipment, so that's the main exemption that we're using here. And just anecdotally, arundo is infamous for being difficult to remove. I think it's even down in Orange County, it's chewed up chainsaws. It's just really aggressive and difficult.
Commissioner Jackson.
Mr. Commissioner, or Mr. Chair, Commissioners, while I respect this is outside of my district, I can tell you I spent 2 years eating lunch in the very bench you photographed, and I'm very familiar with the pernicious and rather significant nature of it there, and also the terrain being difficult. My question is, you acknowledged best management practices. Could you, I think if you elaborate there, that may help with some of our sensitivity, because I read that this is a best management practice. Could you define that and help us along with that?
Mr. Chair, Commissioner Jackson, I'll touch on that, and then David jump in if I miss anything. But the primary best management practice is to have a licensed, someone who's licensed to apply the pesticide, who's trained in it. There are very specific instructions on the use of it based on wind direction and speed, and whether people are in the area, and if it's raining or not. So they're the very strict requirements that you must follow when you're using, that are required by the manufacturer. And then they will be having people staff the area to make sure that no one gets near the foliage while they're applying it. Those are the primary protective measures. And David, I don't know if you have any more to add.
One of the significant issue is the application technique, which is the cut stump application technique. We will be cutting the grass down and immediately following up with the applicator behind the cutting. And they're using very small application equipment. It's going to be low-pressure applicators. Mr. Jackson, being familiar in agriculture, you know that power equipment can cause a bit of drift. Well, we're not using power equipment. We're going to be using handheld sprayers that produce very little pressure, large droplets, and a very directed spray to this small grass culm, a small grass stump, mini stumps, but very directed, small, low-pressure spray with very little drift, very low impact.
Mr. Chang, are you aware of any literature or other information which would reveal the potential harmful effects to park users who, by the application, will be present at the time of application?
Well, people will be prevented from contacting the spray during the re-entry interval. That is the legal standard for pesticide applications. As far as health effects, glyphosate is considered a relatively safe. It is in the caution level of toxicity in regards to human health. It is a weed killer with no known effect to people. People would probably argue with me, but it's a weed killer with effect primarily on plants. Okay.
My struggle here is I want to get rid of this weed as much as anyone, and certainly at Lookout Park it's taken over, and and really reduces the enjoyment, I think, that the public can make of that park and the beach below. But my concern is that we do everything we can to analyze the potentially harmful effect of using the pesticide and then mitigate against that. And what approach has been taken here is to treat it as exempt from any CEQA analysis, which is questionable given the potential for harm if someone accidentally contacts it or doesn't wear proper protective equipment in applying it. And that's my concern, is that maybe the level of environmental review is inappropriate. Not that we can't get to the same place, but that we might need a different route. And as I review the CEQA exemptions, there are exceptions to the exemptions, and basically the one that always concerns me is that it's 15300.2 subsection C, which says a categorical exemption shall not be used for an activity where there is a reasonable possibility that the activity will have a significant effect on the environment due to unusual circumstances. Now that's vague, and if we weren't dealing with a pesticide, if we basically were dealing with gopher traps or something like that, I would say that doesn't come into play, and that's my concern. I just express it here. I'm not saying that I can't make the environmental findings, but I'm not comfortable making them in the context of an exemption.
Well, some of the issues are that, this is a pesticide registered with the EPA. It is approved for its use in the situations where it's being used. I work for the Agricultural Commissioner, who is the regulatory agency who enforces the rules about pesticide use. I have been a pesticide enforcement inspector for 20 years and recently switched to doing this weed management work. So we issue the permits to allow pesticide use. We regulate the applicators who apply pesticides. So when I'm hiring the contractor who is applying the pesticides, if he doesn't use them properly, then he's going to, hear it from us. So.
Which is a complete answer to a concern that every effort is being made to minimize any environmental effect of the application process. I have no doubt that in your hands that will be done. My only question is, on this record, are we able to find that an exemption from CEQA applies, so we don't even have to look at the CEQA process in terms of this project? If it were only Lookout Park we were talking about here, I might have less concern. But we're really talking about a program, as I understand it, that could be utilized throughout the county wherever this species occurs. And maybe not just with public application, but with private application as well. So I want to get it right so that there isn't a challenge by the public later on to our approval based on the lack of CEQA analysis. That's my concern. And believe me, it's not personal to you. I'm delighted that you're here and in charge of this project. So perhaps, Ms. Gibbs, you have a response to my concern.
Mr. Chair, yes, I completely understand exactly where your question is coming from. We do, in this case, and maybe I needed to explain this in more detail in my staff report, but again, in this case, we do find that there are no potentially significant impacts because of the manufacturer's requirements for use and the best management practices that the Ag Commissioner's Office will be using. I'm hearing you loud and clear, though, that we need to explain this better in our staff reports in order to make it abundantly clear to the decision makers how our decision is made to find that this project exempt, or these types of projects exempt.
That's certainly going to be helpful to the commission in the future if this comes back. And Ms. Slutsky, about the ultimate issue of is the environmental review sufficient in this case, have you had a chance to consider the matter?
Mr. Chair, members of the commission, yes, I have, and my consideration was based on the project as proposed, and I believe that Michelle's response is inaccurate. When the project as proposed, I think you could find that there is no significant effect due to the unusual circumstances. And maybe in other circumstances, a little different application, perhaps it would be different. If they look at all these projects and all the different locations, there may be some areas that we wouldn't be able to make that finding.
So in this case, the specific recommended findings with regard to CEQA, you believe we're able to make based on this record?
I do. I think you could.
Ms. Black, did you want to chime in based on the APA conference or otherwise?
Mr. Chair, not based upon the APA conference, and I kind of hesitate to, but I think in this case, we've got the department who's in charge of regulating pesticide use in the county of Santa Barbara proposing the project and proposing to implement the project. So I don't think in this case I'm concerned that we're making an incorrect CEQA call. I could envision if there's private application of pesticide that we could look at it a bit differently, but I'm not concerned given that it's the Agricultural Commissioner's Office that's doing it in a very controlled manner and appropriate manner.
And that therefore the exemption from CEQA applies here, because that's the finding we're being asked to make.
Correct. There is no exception to the exemption in this instance.
Okay.
We'll go over this in your CEQA training.
That is one of the exemptions, I believe, for a noxious weed by a regulatory agency. So that's the other aspect too that I'm using. Okay, because noxious meaning that this is a regulated weed in the regulations. Right. So.
Okay. Well, thanks all of you for bolstering the record in that regard, because I definitely don't want to short-circuit the CEQA process to get to the right result. Otherwise, we're subject to attack when the proposal itself is so merited. Commissioner Brown.
Mr. Chang, is this the rodeo available commercially?
Yes, it is.
So I could go to Home Depot and buy it? Or I could go to Western Farm Supply or someplace and buy it?
It's perhaps a bigger answer than, but you could.
I
You
could
buy
obtain-
homeowner formulations of the rodeo.
Okay,
Yes.
so I could buy it, and if I were a private property owner and I had Arundo on my property, I could go buy it and do what you're going to do here in
Right, you
public,
could.
without having approval from the county to do that?
It depends on your situation. If you're an agriculturalist, you would have to obtain an identification number, is what we call it.
Okay.
But if you're a private property without farm use, you could purchase it without a permit, registration or registration.
And the Arundo, I guess, is just in listening to Chair Cooney's questions and concerns, is the simplest way I can say it is it by itself, because it's invasive, and it is bad for the environment because it takes up habitat. It doesn't provide any habitat where it displaces native plants.
That's right, and it's also, it was once used for soil stabilization, but no longer serves that purpose because it's known for its shallow root system, which is undercut by water, and then it's brittle, so then it can bring the banks down with it, and so it causes problems for infrastructure because it will back up behind bridge abutments and it has even knocked a bridge off its foundation in Orange County. So.
Okay. It appears the commission's questions have been answered. Ms. Gibbs, anything to add before we deliberate?
Mr. Chair, no, nothing to add.
Thank you very much. Members of the commission, any action recommended here, Commissioner Brown?
You know, it's always interesting to me in the use of chemicals to control our environment. I'm an organic gardener. I use all organic stuff. I don't use Roundup or stuff like that. But seeing this Arundo down by San Jose Creek and knowing that it's just going to take over, I don't know. I appreciate that there are environmental consequences to not doing it, but there are also environmental consequences to doing it. But I do support the project, and I would really like to see the county get rid of Arundo in every creek, on every creek bank. I realize that's a huge undertaking, but this is a good start, and I obviously support the project.
Would you,
Be happy to make the motion, adopt the required findings, accept the CEQA exemption, and approve the project subject to the conditions of approval,
as recommended by staff?
as recommended by staff.
Is there a second?
Yes, I'll second that.
Commissioner Jackson seconds. Any further discussion from the commission? All right, Ms. Oplin, we're ready for the roll call.
Thank you, Mr. Chair. Commissioner Brown?
Aye.
Commissioner Jackson?
Aye.
Commissioner Valencia?
Aye.
Commissioner Cooney?
Aye.
Vote carries 4-0.
All right, thank you very much. Mr. Chang, thanks for coming. All right, we next have a briefing, but we'll take a 10-minute recess before we turn back to that matter. Of October 3, 2007, and we're ready to turn to item 2 on our agenda. If Ms. Oplin will read that into the record, please.
Thank you, Mr. Chair. The Planning Commission will receive a briefing from Planning and Development staff on the Process Improvement Team, PIT, effort with regards to the Process Improvement Oversight Committee.
Thank you very much. Ms. Black, would you like to introduce Ms. Haley?
Mr. Chair and members of the commission, yes. Ms. Haley and I are here today to provide you with a briefing that we were actually requested to give to the board, and we thought it would be a good idea to come to the commission first and get any feedback that you might have. For those of you who have been on the commission for a while, this will probably feel like deja vu. But I think it is important to go back to kind of the beginning of this effort. I'm sorry that Commissioner Blau isn't here today, but I know he always watches either the replay or gets a DVD, because I think this will be helpful for him as well to sort of put this effort into context. So wanted to start off with a background of the whole formal process improvement effort that the department's been undertaking for about the last 5 years. Go over the board action that occurred on May 24th, 2005, and then the continuing work of the Oversight Committee. So sort of, I guess 4 years, 4.5 years. Feels like 5. It's an interesting thing to say process improvement started on a certain date, and I think that's a bit misleading, because I think any good agency seeks to improve its processes as as a recurrent effort, a continuing effort. But we did undertake a very intensive process improvement effort that began in about February or March of 2003, and it started as a result of a number of factors occurring kind of at the same time, or coalescing at the same time. First of all, the department director, who had been here for quite a long time, had left in the fall of 2002. And I was sitting in an interim role, not really wanting to do much of anything until we had a department director, but a lot of things occurred at that same time, including, it seemed like, an unusually high number of pretty critical articles in the newspapers to the department, continuing grand jury reports criticizing and commenting on the department's processes, customer complaints, and when I say customers, I mean just about customers from a variety of places, including the Board of Supervisors office, permit applicants, and even general public members. And then we, at the same time, we're just seeing a really significant amount of staff turnover. So the CEO, Mike Brown, and I talked about it, and we decided that we needed to do something, and we needed to do it sooner rather than later. So we started this process improvement effort. And it started as an internal effort with 6 staff focused pretty intensively on learning what process improvement was about and then analyzing the processes in the department. And they spent several months with a consultant that we hired, being trained in that effort and identifying potential areas for improvement. And then at that point, we went to the Board of Supervisors, and they authorized us to go public because we didn't feel like we could continue in the vein that we had been, where we were really trying to improve our processes on our own, try and guess what people needed and do the best we could. So it was really a very, very public process that began in August of 2003. We had a kickoff meeting in Buellton at Pea Soup Anderson's with, I don't know, maybe a couple hundred people there, probably 200 people present. And then Chair Supervisor Schwartz and Supervisor Centeno sponsored the event, sent out invitations to lots of people trying to get some interest in this. At the same time, the Community Planning Renaissance Group started up, and so it was just a really prime time for us to work with the community. As a result of the meeting in Buellton, we established 4 steering groups, and the steering groups included a steering group focused on the nature of the interaction, the permit process itself, policies and ordinances, and then a more internal group on training tools, supervision, and management, more internal to the department. And those steering groups met for about the next year and a half, and made some significant inroads, not the least of which was developing partnerships and relationships with people in the community, both the development community, the environmental community, neighborhood groups, et cetera. That's really held these efforts together, I think, in the longer term. So it was pretty remarkable, the amount of work we could do within these groups that we really couldn't do and wouldn't have the support to do if we hadn't included them. So just a few things that we did, and the picture that you see on this slide is of an event that we held out at UCSB for staff, so that the staff could really get an understanding of all of the different things the steering groups were doing. And that little exhibit was one of them. But we did the application submittal checklist, which is online and is, I think, a very useful tool to applicants for ministerial permits coming in. We did a tremendous amount of website upgrades. If you've looked at our website recently, I think you'd agree that there's a lot of information available on the website that wasn't a few years ago. We instituted a customer suggestion and feedback process, which we've changed over time as we've learned better how to get information from our customers. A lot of public information and outreach. We did a collaboration training for the entire staff on the department, as well as a number of other trainings. And we kicked off and got fairly far into the zoning ordinance reformatting project, which is, as you know, adopted in the inland portions of the county now. We also instituted an exemption process for those projects that are funded through the NRCS on agricultural lands, and we did some things with staff assignments that I think have been helpful. We created geographic assignments as well as a ministerial team in the South County to help better provide good service to our customers. So a lot of work was done. It was pretty broad. It covered a lot of different issue areas. We certainly haven't done everything that even the staff had identified back in 2003 or the steering groups, but we've made substantial progress. And I think one of the things we've learned is that incremental steps are the way to go. We're not going to throw out our zoning ordinance and completely rewrite it. We're not going to throw out our processes and completely reinvent them. And so we take in incremental steps and try and learn from them And there are some things we've done that I wouldn't do again. And you'll probably see me coming and saying, well, we did this, but, you know, we need to tweak it a little bit to make it work better. And I think that's how process improvement works best. So in 2005, early 2005, we decided, for a number of reasons, not the least of which is Mr. Frucci was no longer going to serve as a consultant to the county on these efforts, and we were putting a lot of time and effort in supporting these 4 steering groups. We decided that the way to approach it was perhaps to better use everyone's time and consolidate the 4 steering groups into one oversight committee. And so that's what we did. And it really helped to address a couple of problems we were having, including attendance issues. You know, it's really hard for people to attend as many meetings as we were having at that point in time. We were having a hard time supporting it and keeping up with the work of the committees, and it helped us to really focus our efforts. So the main source of members for the Oversight Committee was the 4 steering groups. We asked everybody on the 4 steering groups if they were willing to continue to serve, and a number of people were. We have applicant representatives, neighborhood representatives, representatives from the agricultural and business community, and board assistants and selected P&D staff who attend these meetings. It is a volunteer group, and it's hard to get certain portions of the community really engaged. We've tried hard, and I'll talk a little bit more about that later. So one of the first tasks of the Oversight Committee was to decide what they wanted to do and to make a recommendation to the board. And the board had actually asked us to do this. We were working on some things I think Commissioner Brown is pretty familiar with, the recommendations on appeals. We were working on tree protection guidelines, and we're finding resistance at the board as we were trying to even set these for hearing. And so the board recognized that too and said, you know, why doesn't the department work with the CEO through Ron Cortez to try and focus our efforts and come up with some recommendations? So first couple of months with the Oversight Committee, we did that, and I'll present those focus priorities and the criteria for process improvement in just a moment, but wanted to kind of quickly go through the process with the Oversight Committee, because I think it's somewhat misunderstood. The Oversight Committee is really a committee that's useful to staff and to the decision makers, but primarily to staff in getting ideas and bouncing ideas off of them as to how the department ought to be changing or addressing issues that the community would like to see handled in a different way or problem spots. So we'll identify an issue that we think is ripe for consideration and ask for their input. Occasionally, they'll come up with an idea they'll ask us to look at, and we just talk it through, and then they review ordinance amendments. But it's really the work of this commission and the Board of Supervisors to institute those changes that require ordinance amendments, so they aren't a real formal body in that regard. So moving on to the May 24th, 2005 action, the criteria that the Process Improvement Oversight Committee recommended to the board and that the board approved was to make the process easier to navigate and more time efficient and cost effective while maintaining the quality of development in the county. So it was clearly the board's intent and the Oversight Committee's intent not to make it easier to develop at the expense of the quality of development, but to try to look for ways to make the process more efficient that would not materially affect the quality of development in the county. And I think that's a really important criteria to go back to. In terms of priorities, there were 5 priorities identified, including improving the ministerial permit process, improving the appeals process, simplifying agricultural permits, improving customer service, and then this zoning ordinance reformatting project, or the land use development code, was specifically called out as a priority work item. So on May 24th, 2005, the board did adopt both the criteria and the priorities, or endorse the priority and criteria. Just a little bit more detail on the priorities. On ministerial permits, our goal was to really separate out among all of those permits that are issued at a staff level, those that are ministerial in nature and those that require more analysis. I think at the time, we were looking at about a 50-50 split on projects that are approved real-time versus projects that required more in-depth analysis by planning staff. And our goal was to make those 50% easier, and the way we went about that was through the zoning clearance process I'll discuss in a moment, and to look to see if we could shift some of the other 50% into a simplified class. I'm not sure how well we've done on the 50-50 split, but I think of those that we've attempted to make more ministerial, we've done that through the zoning clearance process. On appeals, again, we were trying to eliminate the possibility for appeals on projects where there was nothing that could be done if a project were appealed. In other words, it was so ministerial that there was really no action that your commissioner or the Board of Supervisors could take. And we also wanted to encourage people to participate in the planning process early, when projects can really be changed and modified, rather than at the end of the process when a project's completely developed and it's a real adversarial position. And we attempted to do that through better noticing to neighbors. The third priority is agriculture, and we're still working on this. The only real action we've been able to take on this, because of the complication with the other agricultural efforts that have been underway, is this NRCS process that we did early on. We will be, I think, engaging in trying to identify additional agricultural projects that could either be exempt from permits or at least subject to zoning clearance. And we had gotten pretty far into identifying projects that would fall into that category. And I think we're at a point in time now where we can probably re-engage in that process. And again, we're looking at simplifying the process and really identifying things that would be considered ministerial. Customer service. Our goals were to improve the relationships between the staff and the public, to provide better information to the applicants and public, and to develop a more solution-oriented approach to the permit process. And when I say that, I don't mean a process where we always say yes, but that we provide more guidance. Instead of just saying no, we'd say no, but you could do X, Y, or Z, or you could modify your project to make it consistent with our ordinances. And I think staff has, by and large, tried to do that all along, but it does take a bit more effort, and I think it requires everybody to be just more cooperative in the process. And the fifth, and the last was reducing staff turnover, which is something that we've been working on for a long time in a variety of different ways. Fifth is the zoning ordinance reformat project. And our goal was to reformat Articles 1 through 5 for the county and Montecito. And as the commission knows, we have completed that initial phase of the work. We have a standalone zoning ordinance for the county as a whole, and are nearly there in Montecito. The next effort you'll see, I think in October, is the reformatting of the Land Use Development Code for Montecito and the Land Use Development Code for the county, that takes from the county's code the coastal portions that apply in Montecito. So then we'll have completed that, and we'll await certification by the Coastal Commission staff itself. Okay, so back to the Oversight Committee. As I had indicated before, this is a voluntary committee. Wasn't a committee that's appointed by the board. People volunteered to participate, and amazingly enough, some of the people who initially participated on the steering groups have continued and are still involved in the Oversight Committee. There's a core group of about 15 to 20 who attend these meetings. As I indicated before, it's hard to really engage local community representatives, even representatives of the environmental community. It's hard to engage them and keep them engaged. And we've really attempted several times to get more representation. I've begged the Environmental Coalition to send people. We've contacted a number of different community groups, and we've had some results. Victoria Green does attend on behalf of the Montecito Association, which I think has been extremely helpful, and she typically attends most of the time. And we've had other people attend sporadically. Tish has been a diehard participant. And I was planning on introducing her at the end of the presentation and asking if she had anything she wanted to contribute to the conversation today. We also tried video conferencing, which was a dismal failure, to try and get more people to participate from the North and the South County. Obviously, there's this commute tension, and people in Santa Barbara County, by and large, do not like to drive very far to go to meetings. And so that's been a bit of an obstacle, and I think everybody in the group agreed after we tried our video conferencing session that it just didn't work. The level of engagement was really quite uneven, and so we decided that we would all continue to drive to Buellton and try and make the best out of that. We also tried different restaurants. That didn't work. So we're back at Pea Soup Anderson's in Buellton every fourth Thursday of the month. The Oversight Committee is not a Brown Act committee. They're not a decision-making committee at all. They give advice to the department, and they provide their recommendations to the Planning Commission and Board, but they're not substituting or sitting in the stead of any county decision makers. We do, though, try to widely distribute agendas and minutes, and we post them on the website. The meetings are open to the public. We don't try and keep it a secret that where we meet. In fact, quite to the contrary, we'd love it if people attended. And the focus to date has been on P&D issues, planning and development issues, although other departments have used the committee to bounce ideas off of the last meeting that occurred. Just an additional comment on the Oversight Committee. I think it's been just a fabulous place to go to present ideas, because while not every interest is always represented at a meeting, we know where at least some of the concerns are going to be, and we can try and address it and let the Planning Commission know and let you struggle with those issues where we may not have full agreement. So I think it's always better to know more than less as we go through our planning process, and so it's just been really a helpful process for me. And interacting with people who sometimes are speaking against the department in a less formal structure has been just a really fantastic opportunity. Just a little more detail on how the Oversight Committee process works. Like I said, ideas come from everywhere, from the Planning Commission, from staff, sometimes from the committee itself. And we use the committee to initially flesh out those ideas and see whether it's something even worthwhile to pursue. If we decide it's something worthwhile to pursue, typically we do some research. We come back to the Oversight Committee, we provide them data. Oftentimes we'll look at the data and we'll say, gee, there were only 5 of these whatevers in the last 5 years. Is this really worth our effort? And, sometimes the answer is yes, and sometimes the answer is no, depending on what those 5 things are and how long they take. They'll make a recommendation as to whether or not they think we should go forward and how. Then we typically have come to the Planning Commission in a work session or workshop and gotten the Planning Commission's input before investing a lot of time in developing ordinances, or whatever code changes we would need to make. And if the commission seems generally supportive, and oftentimes it's your commission and the Montecito Planning Commission, then we'll go back and draft language, sometimes run that language through the Oversight Committee, sometimes not, depending on how complex the issue is, and then bring it forward to the Planning Commission, ultimately to the Board of Supervisors for consideration. So you can see they're part of this process, and I think an important part, but certainly not the whole process. In terms of accomplishments, I think the new zoning clearance process has been a very helpful one, and one that we've expanded into additional areas since we first devised it and applied it to tract maps, to the development of lots in tract maps that were approved since 1990. And it's proved to be a very helpful tool. So the zoning clearance process is identical to the land use permit or coastal development permit process with two important exceptions. Number one, projects are not noticed, and number two, they're not appealable. So the theory behind zoning clearances is that the project itself has gone through enough discretionary review, in the case of tract maps, through the tract map approval process, that the subsequent permit does not need to be subject to notice and appeal. So we applied that to tract maps countywide, not in Montecito, because we see almost none, and at the time just didn't feel like it was worth pursuing. The Orchid Community Plan in the Old Town area and elsewhere we've applied it. Very recently, we've applied it to discretionary projects or ministerial projects following discretionary projects, so conditional use permits and development plans. And it's eliminated this double appeal process that many projects, and triple appeal process in the Coastal Commission, that many projects were subject to. And I think this is one of the improvements that we've made that the community, the development community, has been most pleased with. Second kind of grouping of accomplishments is the CDP process, and we've actually put I would say the less significant of the two first, but in terms of CDPs, we have CDPs in the appeals jurisdiction that have to go to a public hearing, and in the rest of the county, that occurs at the zoning administrator level, and we have a process to allow waived hearings for minor permits. Otherwise, everything is required to go before a public hearing body. In the Montecito area, where the bulk of our CDPs in the appeals jurisdiction exist, because the Montecito Planning Commission sits as the zoning administrator, there wasn't really an opportunity to have a waived hearing, because the Montecito Planning Commission would have to have a hearing to waive it. So we fixed that and have now an effective waived hearing process in Montecito, and I think that's will ultimately help people. This is still subject to certification by the Coastal Commission, so it's not in effect yet, but I think it'll be helpful. The other process, and I think this is very significant, was combining the coastal development hearing process, or the coastal development permit approval, with the discretionary permit approval. In the coastal zone, particularly in the appeals jurisdiction, and for conditional use permits, which are all appealable to the Coastal Commission, a permit applicant previously would come to the Planning Commission, let's just use a CUP example, come to the Commission for a conditional use permit, and then would be subject to appeal to the Board of Supervisors and to the Coastal Commission. And then they would come back in and get their permit basically to affect that approval, assuming that they got approval through the process, the coastal development permit, and that would also be subject to appeal to the Planning Commission, Board, and Coastal Commission. By issuing the CDP, or approving the CDP at the same time as the discretionary permit, the project's really only appealed once. And this is something the Coastal Commission Coastal Commission staff has really wanted us to do for a long time. And so I think that this is an amendment that they're going to work into the current package that they're looking at on appeals and coastal development permits in advance of actually getting our submitted process. So I'm really hopeful that this will be in effect in the next few months. because I think it's one of the biggest improvements that we've been able to make in the coastal zone.
Ms. Black, while you're on that, as a matter of curiosity, where does the architectural review come into play when you have a combined hearing, one shot for both the development permit and the conditional use permit?
Mr. Chair, that's a good question. The process will continue as it does, as it is now, and that is the BAR will get through conceptual review before your commission or the Montecito Planning Commission reviews a project, and then the subsequent preliminary approval will occur before the CDP is issued. And the BAR decision, the preliminary decision, is also appealable. So there is still the potential for a design appeal, but I think it limits it substantially.
Thank you.
Okay. So I told you what I thought the biggest accomplishments for the development community were. I think the improved land use permit noticing has probably been the biggest accomplishment for the neighborhood community and environmental groups. And although I don't think the development community finds this to be problematic at all, because it really serves their interests as well. Prior to making some land use permit noticing improvements, we just noticed the project at the end of the process from at approval by posting the site in 3 places. That's all we were required to do by our ordinance. And I think we improved that by requiring that mailed notice occur upfront when the application is essentially when it's submitted, and then we still post the site in at least one location. So the improvement here, I believe, is twofold. One, that there's mailed notice, so people are more effectively noticed, and it's at the beginning of the process rather than at the end of the process, so people can become involved early rather than at the end, and their only course of action is to appeal. So I think this has been a tremendous improvement. We've also made attempts, they're not perfect, to provide more information online. It's not the easiest system to use, and we'll continue to work on that, but I think we're going in the right direction, and we, as you'll see in a minute, are continuing to work on some noticing improvements that we've previously spoke to the commission about.
Commissioner Brown.
Yeah, thank you. I just wanted to tell Ms. Black that I think for the community, this has been the most important thing that has happened out of your process improvement effort. And you've, clearly articulated the differences that letting people know what's going on before anything happens has just been huge. And I think probably, even though it's been good, you've probably seen more appeals as a result of this because people are more aware. But I think it has been very important for maintaining the quality of our community. And I just, having been a part of setting up some of these things and working on appeals, I just feel that it's been a very valuable addition to the planning process.
Good. Next is appeals, and we did move the timing of appeals up so that BAR appeals occur at preliminary approval, and the goal is that preliminary BAR approval and the action on a land use permit or coastal development permit occur relatively simultaneously, so that if an appeal is filed, an appeal can be filed on both actions. But I think this is a major improvement as well, and serves a couple of purposes. One, applicants aren't required to do full working drawings before an appeal is potentially filed on their project, and that was a problem in the past, and it really set people in opposing corners, if you will, in the appeal process, because they'd spent so much money and time really detailing out their plans. They were essentially ready to pull their building permit. And that's a pretty poor time to tell somebody that their project's wrong. So it also gets the neighbors involved at a point where it'll be easier, not the easiest, but easier to maybe affect some changes. We also mirrored the coastal zoning ordinances language on who can appeal and how they have to be involved in the process to appeal, to really encourage people not to come in at the last minute and appeal a project, but to be diligent about being involved in the process. And then finally, we did have local adoption of the land use and development codes for Montecito and the county, which was a tremendous accomplishment. I don't know, I think the commission's begun to use those documents. They've been in play for a while. They are online, they're searchable. Even for me, who learned under the old system, it seems like they're more intuitive, and we've been able to fold into the zoning ordinances some of the practices and old practices of the department that were really part of the code but not written down. So I think it's been helpful to everybody involved in the process. A couple of other things that I thought I should mention that weren't really done under the purview of the Oversight Committee, but things that have occurred in the last couple of years as well are the CEQA guidelines changes that your commission helped to form about the release of administrative draft EIRs and that process and documentation of communications with consultants, the regional BAR process and setting up those North Central and South BARs from the county BAR. Some things that you probably haven't seen are some things that we've done for the staff. We've produced a permit processing manual that's provided to the staff online through our county intranet, and it links all of the documents document protos that they use in their work, and it's been really a very, very helpful tool. And then, of course, we've continued on with our staff training program and done a number of different trainings. The last thing I kind of want to go over is the efforts that we're currently undertaking with the Oversight Committee. And the first of those I alluded to a few minutes ago, and those are continued improvements to the noticing process. One of the things that you'll be seeing relatively soon, I think, because it doesn't require any particular change in code, is changes to the actual physical written notice that I think will be helpful to the public and help make some sense out of these public notices that even I get in the mail from other jurisdictions and think, whoa, I don't know what this is about. So we're really trying to make them more understandable and usable by people who may not understand all of our lingo and jargon. One of the things that we talked to the commission, both commissions, about earlier this year were more visible posting of notices on site, and I think we've gotten to a point where we're ready to come forward to the commissions with ideas about that. I'm not sure if we're going to make it this calendar year, but maybe early in 2008, given your schedule. And then simplify the preparation of notices. One of the things that I would not do if I had it to do again was to have the applicants mail out notices on land use permits. And it's not because there's been any particular problems, but if you remember when we did that noticing workshop, there were 3 pages of, different ways notices occur depending on whether it's BAR or land use permits or coastal development permits or discretionary actions. And I think our goal is to really simplify that and have as few variations as possible, and when there are variations, to make them meaningful. Another variation we created, and we're probably going to undo, is the just noticing adjacent neighbors on certain types of land use permits. It's more work than it's worth, and so I think we're going to stick with the 300-foot notice radius for pretty much all of our simpler applications. So you'll see some things that are relatively minor, I think, from the commission and the public standpoint that we're going to recommend we tweak a little bit. Another item that we're currently working on is to simplify the preparation of staff reports and initial studies, and we're doing this through technology. We've embedded in our initial, or are in the process of embedding in our initial study prototype, some standard language that applies to every project, like the threshold that we use for a variety of issue areas, and just some information that I think makes it much easier for planners to focus on the important aspects of the initial study, and likewise with the staff report, the important aspects of the staff report, instead of having to reinvent every single section where some of them are just routine. So it's more internal. You may see a little difference in format over time, and I'll ask you for feedback as we roll that out. We won't mess with your the chart of the policy consistency, because I know that's particularly helpful and important to the commission, but I think there are some other things that we could do to reduce some of the duplication in the staff report, say things once and refer to that section rather than duplicate them throughout. And then we're on the cusp of having a fully integrated Montecito land use development code, and you'll be seeing that later on this month. The third is we're continuing to work on shifting items from land use permits to zoning clearance, and right now we're looking at additions to one-story single-family dwellings, and there's some criteria that we've come up with that we think might work. Some accessory structures, and then bringing back in the agricultural permitting items that we had worked on before. We're also looking at the opportunity to shift the level of review on some items that require mostly zoning administrator review, except for the government code consistency. Those are sign plans, septic systems and special problems areas, and road namings. And then we're going to look again at the government code consistency review and see if there's a little bit more we can do there. We'd previously presented this to the commission. Finally, when when Supervisor Wolf and Supervisor Carbajal asked us to prepare a summary of the process improvement work in the Oversight Committee, they did ask about staffing and budget implications. And earlier in this process, in 2003, 2004, and even early 2005, it was a pretty significant budgetary issue. Zoning ordinance reformatting project was quite a significant expenditure. We spent a lot of time in those years on consultant work, a lot more time on staff work. Right now, our staffing resources are about what you see on this slide. It's part of our ongoing budget. There's not a separate line item for process improvement. I think this is pretty normal for most departments. It's really part of my time, part of Mr. Lengel's time in developing ordinances and supporting the work of the department. Staff is needed, and several staff members do come to the Oversight Committee. More of them work on these items or provide input into these items. We have mapping resources that we use, support staff, and then Ms. Saley has been providing us her services in facilitating this effort, working with the Oversight Committee and actually getting some of the work done. And then the last question that was asked is, was there a time frame for the Oversight Committee when it was started up in 2005, and there really wasn't. I think that the people who have been involved with the Oversight Committee, myself included, feel like it's been useful and don't see any particular time frame in which that won't be the case. That doesn't mean in another year or two we might think of a better way to organize the way we receive input, but we still have quite a lot of work to do and feel like it's not the time to end that part of our continuing process improvement. So that's pretty much what I had proposed to present to your commission today. We are going to be providing this update to the Board of Supervisors on October 16th and to the Montecito Planning Commission, unfortunately, after the board hears this, but it's really more informative than information than anything else. So if you have any questions or comments, I'd be happy to entertain them. And I did want to let you know that Dave Cross, who's the chair of the Oversight Committee, is in the North County. Tish Gainey is here, and she's been quite a participant in this effort, as well as James from Supervisor Wolf's office. So that concludes
Thank you,
my
Ms. Black.
presentation.
Commissioner Brown has a question.
I just have a question. You've done a lot of great things, and it's been very beneficial to many in the community and to your department as well. you indicated that there are a lot of things that you'd like to bring forward. Do you sort of have some thoughts or about where you want to go, what you want to do, what you want to look at, where it's going to take you? I think it's great we get these periodic updates, but I think it'd be nice to kind of shine that light on the future too, so we would have some of that information.
Well, Mr. Chair and Commissioner Brown, really the items that I presented as our current work efforts are going to take us a while to do. So we kind of try and tackle some of those, and then we think about other ideas. But rest assured, unless we're told by somebody else, by either the board or the commissions, that they want us to focus on something other than those 5 priorities, we'll continue to be focused on those priorities and learning from things that we have done and from interactions with our constituents. So,
Commissioner Jackson.
Yeah, just a couple of observations and some questions. As I look at this, just one observation, I was looking to see how your feedback loop closes, how you take what you've generated and how do you get it into process change, but also how do you define success? Do you have any metrics or core metrics that help you? Because it would seem to me that all of this makes a great deal of sense to me as a planning commissioner. It addresses all kinds of things that even more than I am really fluent in. But at the end of the day, who are you supposed to satisfy? How do you define success? And are you going to run into the same type of challenges among core constituencies that led to having to initiate this in the first place? So that is a question. And also, in this process, I'll just throw all the questions out at once. Do staff feel supported in this process? Because I know you refer to turnover, and I would imagine that the true addressing of turnover probably happens elsewhere other than this committee. And also issues of accountability. There are multiple constituencies here to satisfy. Those who get the service, those who give the service, those who are accountable to the public for the provision of those services. And trying to define, how do you know if you're meeting the objectives? That would probably be it.
that's, Mr. Chair and Commissioner Jackson, that's a very good question. It's a hard question to answer because defining success in the land use realm is elusive at best. It can't be that everybody's happy with the result, because we know that's never going to be the case, and it's difficult. We have lots of different ways to quantitatively measure whether or not we're successful, but much of it is in the quality, both the quality of development and the quality of service. Quantitatively, we have a number of what we now refer to as key performance indicators in our budget process on the timelines for processing projects that we look to. We can look at the number of appeals that are filed, although I'm not sure that it's easy to distinguish one particular change affecting the number of appeals. So there's lots of things that occur at the same time that make it pretty difficult to say, oh, well, we made this change in the appeals process and now there are fewer or more appeals. I don't think the correlation is quite that direct. In terms of quality, I think we look at a couple of things, and one is what kind of feedback are we getting from the people we interact with, both the people who apply for permits as well as the people who interact with the permit process, and are they feeling like they're heard, they're being treated fairly and competently. I mean, that's a very, very important part of this, but it's more qualitative. And then the other side of it is, do we, the community, feel like the quality of development is maintained? So there's so many different facets of this. It's really hard to say, oh, well, that noticing procedure worked, quote unquote, without looking at all of these factors. we tend to focus on the quantitative factors, but I think we have to look at the qualitative too. And so we seek out feedback from our various customers in formal and informal ways to try and get a handle on that.
Commissioner Valencia.
Thank you, Mr. Chair. One of the things that probably needs to go on there, and we haven't talked about much, is training the Planning Commission. There's a high turnover on the Planning Commission occurs, but the Planning Commission, we're people from the community that come in with hopefully just common sense and know how to deal with things, but sometimes you need some basic background on some of these things. We had Mr. Almy talk to us about water one day. Short briefing, I think it was half an hour. Those are very valuable. We had a fellow come in and talk to us about septic systems. He got into the microbes. That was too deep. But we need to know about, where does it feel? What is the envelope? How depth? What is the sogginess of the whatever, sesame loam or whatever, penetration and so on. Ag 1 and Ag 2, what are the uses? For the parcels, what can be done, these things through, I've seen you give presentations and a 1 hour type thing, just a quick review, continually bringing those things to the Planning Commission. I think the training is essential, like it's essential to your staff. Many times I call up the Santa Maria staff and they're in training, and I call down here and they're in training. But the Planning Commission has had, since I've been here, probably about 9 years, we've had 2 major training sessions, and I think we need to have many more. I know it takes time, but it's essential that the people making the decisions know almost as much as a basic planner. Thank you, Mr. Chair.
Thank you, Commissioner Valencia. We have Ms. Gainey, who's submitted a speaker slip. Would you like to?
Mr. Chair, if I could, if you could go to Mr. Cross first.
Oh, okay.
Santa Maria, he's kind of the conclusion of the staff presentation.
You're part of the presentation,
Kind
Mr.
of.
Cross. Good morning.
Oh, thank you. Thank you, Mr. Chair and members of the commission. I'm Dave Cross, and I have the privilege of chairing the Oversight Committee for the Process Improvement Effort. And Ms. Black did a great job talking about the nuts and bolts as to what we're doing on the committee. She also mentioned this has been going on for 4 years, the process improvement effort. Sometimes it seems a lot longer than that, but we've accomplished quite a bit in those 4 years. And I just want to talk just for a minute or two about the committee. The people in our committee are diverse, extremely knowledgeable and hardworking, and each brings something to the table, whether they're members from the public or from county staff, or even representatives from the county supervisors who've been attending. Everyone provides input. We have members in our group who've been involved since the beginning in 2003, when the effort was initiated by Supervisors Joe Centeno and Naomi Schwartz, and this provides the core of our group. And when you look at the hours that have been given by the public members, they don't add up into hundreds, they add up into thousands of hours. Now, I'll tell you, there are very diverse viewpoints that are voiced at our meetings, and sometimes it's hard to find common ground, and yet we work through this to get changes that constitute real improvement. And I recall Commissioner Brown, when she was on the committee, and I think she would agree that the Oversight Committee is a prime example of people working together for a common goal. And if you ask anyone on our committee, anyone, whether this is working or whether we're making a difference, I'm sure that they'll tell you, yes, it is working, and yes, we are making a difference. So I just want to end by urging your continued support for the process, and I also invite you to communicate with me or Diane Black anytime you'd like more information. Thank you.
Thank you very much, Mr. Cross, and for what I'm sure is a big chunk of your week every week and the ongoing process. One thing that Ms. Black emphasized is there isn't an ending point for this effort and for the committee, which implies that you may have a long period of service ahead.
You know, we have talked about that as a committee, and that core group is in. We're in for the long haul.
Good. Thanks again. Any questions for Mr. Cross from the commissioners? Doesn't appear that there are any. Thanks for coming down today.
Thank you.
All right, now Ms. Gainey.
Good morning, Commissioners. My name is Tish Gainey, and I live in Hope Ranch, and I am one of those longtime members of this effort, having served from the beginning on, I guess we were called PIT 2, the permitting process subcommittee, and then I volunteered to be on this oversight committee, and I have a couple of concerns. I'm just going to address a couple of concerns because I think that the presentation was very good and stated well our accomplishments, but I think there are a couple of things that you need to be aware of. My main concern is the makeup of the committee right now, the oversight committee. I want to add that the staff and is nothing but gracious and helpful in trying to, get more people and all this kind of thing. But I don't exactly know how this can be addressed. And Ms. Saley has worked on this also. But, if you say you want to get the thinking of the community out of this committee, then this committee should represent the community. And almost everyone who's on the committee is from the development or the planning side of things. They are architects, they are, expediters, they are developers, they are lobbyists who represent the building industry and CoLab. And, occasionally there are what I would call just general citizens, but they kind of float in and out. And, I'm one of those people. And Ms. Black said I've been coming regularly. Well, I've tried to, but last year, for instance, I couldn't attend a lot of meetings because I was on the Goleta Valley Visioning Committee and I had conflicts. But I just am concerned about the makeup, and I'm concerned that sometimes when outsiders do come, they are not sort of greeted all that well by some of the other members. I'm not. Staff aside, staff is always gracious to people, and Ms. Saley is too, but it's been difficult, I think, for other people to kind of come on board here. And so I'm glad that you are sort of someone who sees everything that happens, or most of what happens at our committee before it goes on, because you have more of that global outlook. And my interest in even serving on this committee and having stayed with it for so long was because I am concerned about, the quality of what is built and developed in our community and in maintaining the natural beauty of our county, which we all know is just, what really makes us a special place. So I did want to address that, and I don't know the answer because I know that both Ms. Black and Ms. Saley have tried very hard to figure out ways to get more people to come to our meetings, but, to drive from, say, South County to Buellton or from someplace else to Buellton once a month is, for somebody who really, quote unquote, doesn't have a horse in the race, is asking a lot. And I also want to say that as far as the makeup of the committee, it is more heavily North County, and I think it's because of probably where the meetings are, and we did try to do, I'm talking minus the staff. If we're just talking about people coming who are architects or citizens or so on, it's just easier, I think, for them. So, the committee is not consistent all the time. There's times when, I don't know, you may not have any just neighborhood person there. And the other thing I have a concern about is that you're right about this kind of follow-up. When we were called oversight, I thought, well, we kind of we'll look back at some of the things that we've done to see how well they have succeeded. They accomplished the goal that was intended. And I think that we really haven't had the time that much to do that because we've been sort of trudging forward. But, as just a citizen, I often, people will tell me, oh, I tried to use the such and such on the website or whatever. These things that we thought we improved and maybe it didn't really happen. I mean, these are they're much smaller things, but nonetheless, they are the things that go to how people, initially interact with the Planning and Development Department. So I think that we need to spend more time on maybe reviewing some of the things that we've done to see if they really truly are working and are accomplishing the goals that we had intended. And also I am concerned about the continued turnover in the department, because that was one of the things that initially we wanted to address. And I think it's probably harder for maybe outsiders to find ways to correct that. But I mean, I think it's something that hasn't reversed itself, and so that is still an issue. So I just wanted to bring those things up. I think the last two meetings we had actually were very productive, because we did have a little bit of airing about, who represents the committee and who doesn't represent the committee, and who, when you're a novice or not in the business, lots of times it's intimidating because there's a lot of jargon used and shortcuts, and you don't really know what people are talking about, and you don't want to be put down because you don't know what they're talking about. But anyway, I think that we've had a pretty good back and forth, and the last two meetings, I think we kind of turned a bit of a corner. We have more representation from the supervisors' offices, which is good. And so anyway, I just wanted to give you my concern about particularly the makeup of the committee, and if you have any thoughts on how we could make it more representative, we're all ears. Anyway, thank you.
Thank you very much. Ms. Guinea, a question?
I actually have a question just based upon Tish's comments about reaching out to the community. I know in the past that you have gone specifically to groups, AIA, other groups on the South Coast, and presented these, whatever you were working on at the time. Had you thought of doing that again? If you have something specific of going to them rather than, in addition to going to your oversight committee, doing that, or even, I know that there's the Mission Canyon group is active, whether or not you ever had anything that you could present to the PACs that are being formed and are in place, if that would be helpful to try to reach more people in the neighborhoods who are community members. I think when you first started that you did some of those things, and I think those were fairly successful for you. So that's the only thing that I could think of that might be of some help.
Right. Mr. Chair and Commissioner Brown, we did go to the CPA probably 3 months ago, Citizens Planning Association, sorry. And we try to make those links, but we could probably try harder. So, yeah, it's a good suggestion. We also had some meetings with the Montecito Association as they were, changing their board and I think connected in a good way, and now they do tend to send Victoria Green, which is helpful. So, I think it's good. The attendance by the supervisors' aides, I think, is really valuable, because I think the committee itself feels like their work is more important when they attend, and they also feel like they get feedback, from the board offices on where we're going earlier than we would if we went through the whole process. So I think that's helpful too. But yeah, we can certainly offer to present to more community groups.
The point Ms. Guinea made about general representation on the committee is certainly a valid one, but it goes to what is the weight of the committee's recommendation. If the committee is not representative generally, then its recommendations may not be given the same weight by the decision makers as a committee that's recognized as representing all points of view. That's not to say that even a lopsided committee wouldn't have valuable suggestions to make, which could then be thrashed out in the public forum with all the public present. And I think the Planning Commission has served that role. Some of the suggestions have been modified or even undercut by the public discussion that follows in this forum and others that are possible. But it's not to say that the initial ideas, what is of concern to the development community, that portion of our community that has to work with our rules and has frustrations with particular processes, that's not to suggest that their ideas aren't valid and shouldn't be discussed as widely as possible. Commissioner Jackson.
Yes, thank you, Mr. Chair, Commissioners. Two things come to mind with your remarks. One is I'm sensitized to this north-south discussion, particularly as it pertains here from the standpoint that I don't always see it. I mean, if you are an engaged stakeholder, you will put yourself in a position of involvement. So I'm kind of interested to know what the most conspicuous shortcoming that you've experienced as a result of that, if there is one. And finally, as a suggestion, there is one of the challenges, I think, in inviting and experienced members of the community to participate is the long-term focus versus the short-term. And if you could create what I'm experiencing in other groups, a mission focus, where you go project by project, and you invite people in for a specified chunk of time, specific objective, and invite for that, and then they're done, they can re-up. But if you invite someone for a long haul, people recognize they want to make a commitment they can commit to and can participate in. So I would encourage that if you can break up your, boy, I'm getting redundant on this, break up the decisions or the issues into manageable action steps for people that might assist in generating interest, would be my only encouragement there. It's really a long-term focus versus a short-term focus. But I felt your comments were helpful.
That's helpful. That's a helpful suggestion. Appreciate it.
Commissioner Brown?
Thank you, Mr. Chair. There's been a laundry list of things here that I'm trying to think about, but I did want to thank Ms. Saley because I know that she's been very good at working with the community and facilitating the process and getting information out, seeing all those emails with all those attachments and going through pages of material and going, oh, I'm sort of glad I'm not on the committee anymore. But she's been, I think, done a very good job and has really helped the process. That's my first thought. And my second thought is that I think this has been very useful and informative, particularly about some of the accomplishments that have come out of the process. And I think, like Commissioner Jackson, what I'd like to see is perhaps when there's time is to come back and relate to us what has really worked or why it's really worked, or what hasn't really worked, and why it's not working, and where you're going to go. We're always sort of interested in appeals, having worked on the appeals. It's, we've been seeing, I think, for one hearing, I think there were 3 appeals from the 2nd District, which was kind of unusual, but maybe to look at some of those pieces where you are in process and you don't feel it's being successful, or maybe something that's been really successful, so that we could hear about it. Because I think these shows get televised, and I think it's important that this is another way for the community to know what you're doing. So and it's a way for us to know too. So it's helpful. Thank you.
Yes, thank you both. I for one value the ongoing behind-the-scenes efforts, because too often we're slogging through project by project, and we miss the big picture that you're able to take a look at. I think it's a huge sacrifice, not only for staff, but for members of the public who give their time to continually provide input on how to make things better. I don't think there's any better way to test the the efficiency and effectiveness of a function, a public function like the planning process, than to have regular feedback from people. It may not be just what you worked on the month before, but someone has the opportunity to say, you know, what's bugging me now is something else that comes off the wall, and can get talked out in a very healthy way in that forum. And I've heard Andy Caldwell mention on his radio show the existence of this process and how it's being addressed, and it gives him an opportunity to, out of public view, express his feelings about things and get them at least responded to, if not completely addressed. So just as an example, I think it's a very worthwhile service that's being provided, and Ms. Saley and you both provide consistency. The worst thing would be if it was an orphan, and each time the committee met, it was a different representative there. So there's a lot of personal sacrifice in making that work. And we are appreciative of the update, and particularly to Mr. Cross and Ms. Gainey and the other members of the committee for giving their time. Anything else? Anything else from the commission as far as today's meeting is concerned? Appearing not, we have a full agenda next week in Santa Maria, and we'll look forward to seeing you all then. Thank you.
Thank you.